Testing Justice 7. Testing Justice 6. Testing Justice 5. Testing Justice 4. Testing Justice 3. Testing Justice 2. Testing podium.
the first matter before the court is York 24205, Fairfriend Enterprise versus CNC Systems. We are being streamed live on the web. I see counsel are present. I'd ask that you introduce yourselves by saying your names for the record together with the party you represent, starting with appellant.
Good morning, Your Honor. Joe Babilonis on behalf of the appellant, CNC Systems.
Good morning, Your Honor. Daniel Murphy for Appellee Fairfriend Enterprise Company.
Thank you. And counsel, if you're ready to proceed, we'd be happy to hear your arguments.
Good morning, Your Honor. May it please the court. This appeal arises out of a statutory request to inspect certain corporate records under Title 13C. The fundamental issue involved in this appeal is whether a shareholder of record can inspect certain corporate records of the corporation in the middle of ongoing litigation between that shareholder and that corporation. Now, today, you'll likely hear argument from the appellee, Fairfriend Enterprises, that because it is a shareholder, it is therefore entitled to inspect any records at any time, notwithstanding, in this case, the ongoing parallel litigation between the same parties in California. Fairfriend will likely argue that it's a, quote, faulty premise, as suggested in their brief, that the ongoing California litigation is in any way connected to this action before the court today and before the trial court. However, the context of the request that was made by Fairfriend's matters. Fairfriend's arguments and its positions throughout this Maine litigation ignore the fact that the California litigation predated this Maine action by approximately 5 months. It also ignores the fact that Fairfriend had made a nearly identical request seeking nearly identical records in August 2019. It was informed that time by CNC's separate California counsel that the records could be inspected at the California office. Fairfriend never followed up on that request. Importantly, Fairfriend's position throughout this entire Maine litigation ignores the fact that the California action is more than simply a, quote, collection action or a damages action.
Counsel, I see that the green light is on.
Yes, Your Honor.
Can I ask you a question? One of the issues you've raised on appeal is that it was an abuse of discretion to deny the stay of the Maine proceeding in favor of the California proceeding.
Yes.
Isn't that moot now? Isn't that issue moot at this point?
Well, we had our initial stay, or request for a stay, in November of 2022, which was then, after the court's first March 8th order, we then made a supplemental request for a stay as of September 2023.
I know, but isn't all of the relief that was sought in this action already essentially, they've already inspected the records, so isn't the request for the stay moot? I mean, what are we staying?
Well, I think as part of this case, as it's reflected in the docket record, this is set for a bench trial. It was how this proceeding, the sort of final procedural posture was for a bench trial before the...
So it's not a final judgment?
No, we think it is a final judgment.
Well, that seems a little inconsistent.
Well, I'll try to explain. So we're arguing that, yes, it is a final judgment because all of the relief that Fairfriends requested under their application, under Section 1604, which was an order for inspection and the request for attorney's fees. That's been provided. But I guess that constitutes a final judgment, as we argued in our...
Well, they hadn't produced everything at the time you appealed, correct?
At the time we had appealed, there was one remaining document that...
So it wasn't final at the time you appealed.
Well, we were saying the order that they requested, and under section 1604, and the order for attorney's fees, that those constituted the final judgment.
Well,
Counsel,
but it
what's
can't
left
be.
to appeal? I mean, what's left to try below?
Well, we don't think there's anything, but that's the sort of procedural posture of the case was
So isn't this moot?
the court could find that the request for a stay is moot.
Yes, that
But-
was the question.
Our arguments as to attorney's fees, we don't think are moot.
I understand that attorney's fees isn't moot, but it just feels like you can't have it both ways. I mean, either it's not a final judgment, if there's still something remaining, or if all the relief has been granted, then it seems like the request for a stay has to be moot.
And the court may very well conclude that. I guess our position at this point is, given that the court had scheduled a bench trial on this.
What would the bench trial be about?
At this point, I'm not sure what wouldn't be included, but we're saying that we're asking the court to
But what are the issues to be presented at the bench trial?
well, exactly. And I guess we don't know yet. If this were remanded, then the court may say there's nothing else there's no other fact finding or decision that would need to be made at the bench trial.
So at the time you filed your appeal, you were going to have a status conference. Not everything had been produced. No one had entered a final judgment. You appealed, and thereafter, someone produced the final document. So is it your position that an interlocutory appeal of a non-final judgment can become a final judgment by actions subsequent to the filing of the interlocutory appeal?
No, that's not our position. So we under 1604, the shareholder could seek an order from the court for inspection and could seek attorney's fees. And once the case got to that point where both of those two orders had been entered, that's when we appealed, saying that those two orders together constituted the final judgment under the statutory section.
Well, but is there but it's still set for a trial?
Well, based off the docket, yes, that was the initial sort of posture of the case, was
So
to
you
proceed
think
to
that
a
once
bench.
the court entered the order for inspection, regardless of what happened afterwards, and awarded attorney's fees, that's it, it's a final judgment, so this other being set for trial conference, whether or not documents have been produced is irrelevant?
Not irrelevant, but we think that that it was an appeal from a final judgment.
What are you hoping that we will do with your appeal? I mean, if it goes your way, what is our decision going to say?
Well, I think primarily at this point, it would be the court's attorney's fees award to the appellee.
What would we say about that?
That the court abused its discretion in awarding fees based off essentially all the evidence that was presented related to the California litigation.
You're
There
arguing
wasn't
that
any
the
evidence.
refusal to produce the records was done in good faith because you had a reasonable basis for doubt about their right to it.
Exactly, under 1604.
There wasn't really any evidence presented, though, was there? There's an affidavit of Mr. Chen in the record, but that was put in by Fair Friends. You put in a copy of the pleadings. Is that it? Is that the record that we have to base this on?
Yes, all of our, as part of the initial November request for a stay, excuse me, the pleadings and the discovery documents and CNCs, under the California procedural rules, it's my understanding they have to seek leave to file a counterclaim. So at that point, we had provided the court that notice that CNC was seeking leave.
So there was no request for further findings on your part, so we have to give every reasonable inference its due on appeal, don't we? And how does that square with your position that this was an abuse of discretion?
Well, I think under the court's attorney's fees order, excuse me, that there were no findings I think when you look at the evidence that was presented to the trial court through the second motion for a stay, which included the trial court in California's order, as well as the CNC counterclaim, that those would compel a finding that these included the same parties, that we were prosecuting, CNC was prosecuting a claim in California against Fairfriend that was directly related to whether Fairfriend had, as part of their acquisition of the shares.
Are you arguing that as a matter of law, if there's concurrent litigation in another forum, that a shareholder doesn't have a right to request these records?
Not as a matter of law, but there's definitely case law that supports that we had cited in our brief.
Well, the case law provides that you look at the primary purpose. It's not a black letter rule, is it? And didn't the court here basically find that Fairfriend's purpose was legitimate? They had a good reason as a majority shareholder to be seeking these records for several reasons, I believe.
They did, as the court, as part of the first March 3rd, excuse me, March 8th order. When we had presented additional pleadings to the trial court, which showed that the actual acquisition of shares by Fairfriend was being litigated in California to see if that constituted fraud and intentional misrepresentation against the same parties that are involved in this Maine lawsuit.
So I'm just trying to unwind your argument a little bit here. As you know, the duty to produce is there unless you prove that it refused inspection in good faith. And I think in answer to Justice Douglas's question, you said the reason that we refuse in good faith is that there's litigation pending in another state. Is that the sum total of the evidence as to why your client refused the inspection? Is there anything more other than that fact?
Yeah, I think up until the time from when this Maine action was commenced. So I apologize. I'm getting over a cold and I keep eating water.
Me too.
Me too.
From July 2022 up until the complaint is filed. The reason I wouldn't consider it a refusal to inspect. It was just CNC was engaged in litigation in California, represented by counsel. Fairfriend's represented by California counsel. And then at that time, they sent a separate request across the country to Maine.
But that's the four corners of your evidence to support the contention that it was refused in good faith.
Yes.
Okay, there's nothing else that we're missing here.
Right. No, I guess it's the entirety of the California litigation and the documents that were presented to the trial court.
But didn't the court here find specifically that there was not an identity of parties and not an identity of issues presented by the separate pieces of litigation?
The court did in its initial March 8th order. But as we had showed in the subsequent pleadings that were provided as part of the September 2023 request for a supplemental stay, that these are all the same, that Fairfriend group, the overarching group, that Fairfriend's, DMC, and MAG Automotive are identified in the pleadings as sister companies. They're all the same, essentially the same corporate group. I see that my time is up.
Thank you.
Thank you.
Attorney Murphy.
Thank you, Your Honor. Good morning. May it please the court. This court should determine that the Superior Court did not abuse its discretion in refusing to stay the main action, compelling production of books and records requested by a majority shareholder, and it did not abuse its discretion in relation to the award of attorney fees as permitted under 13C MRS 1604. CNC Systems has persistently and repeatedly pointed to the existence of a damages lawsuit in California involving multiple plaintiffs, including Fairfriend and CNC as a defendant, as a reasonable basis to doubt Fairfriend's right as the 52% owner of CNC to obtain corporate books and records. First, majority shareholder rights are not waived if there's litigation pending elsewhere. Under the applicable statutes, there's no such exemption. Shareholder information rights in a Maine corporation are not eviscerated if there's a damages action pending elsewhere. They're not mutually exclusive, they're not waived, they're not destroyed. More importantly, the Superior Court on multiple occasions determined that the existence of the California action did not provide a basis for denial by CNC because of a reasonable doubt as to Fair Friend's shareholder rights. Under the so-called first order of March 8, 2023, the Superior Court found a proper purpose for the demand from Fair Friend. It expressly found the demand was not motivated by a desire to seek documents for use in the separate lawsuit in California. The court found that that CNC had taken actions that would cause any majority shareholder to have legitimate concerns. Regarding the California action in particular, the court found that the parties were not identical in both actions. The issues between the actions were not an exact match. Fair Friend's main action was not designed solely to harass an adverse party, and the main action was not designed to gain an advantage in the California action. The order compelling production of documents, this portion of the first order, was not appealed from in this appeal, in this proceeding. Therefore, the argument that the California action provides an excuse not to produce documents no longer has any vitality whatsoever. The court rejected it, the findings are clear, and they're supported in the record. Undeterred by the first order, CNC repeatedly wheeled out its California action argument, asserting that Fair Friend lacked a good faith basis and a proper purpose for its demand. It continued to argue that the California action provided a basis to deny production of documents. On May 8, 2023, CNC filed a motion to dismiss in response to Fair Friend's motion to enforce because of the lack of production of documents. CNC argued at this time it produced all documents required under the first order. CNC was wildly wrong about this assertion made to the court. And then on September 7, CNC filed a second motion to stay, arguing...
The green light is on. So why couldn't you get all these documents in the California discovery?
The California action is a damages action by 3 plaintiffs against CNC and also its self-appointed CEO, Brian Chen, who lives in California. But at its base, it is a collection action. It's a creditor seeking money because of the failure to pay for equipment provided to CNC. Fair Friend, which is owed only $300,000 in comparison to sister companies that were owed millions, is the 52% owner of CNC. And so as there was a failure under the April agreement of 2021 to perform by CNC, as there was essentially ignoring the request for books and records, there's acute concern on the part of Fair Friend as to what was being done at CNC, a Maine corporation with a Maine domicile, with respect to...
Could you not get these documents through the California action, through discovery?
Well, I'll give you a great example of a mandatory document under the statute that's required. It's a current list of officers and directors. And the president of CNC is affiliated with Fair Friend. He was unilaterally demoted by Brian Chen in Maine through corporate filings that are part of this record. That's not something that you can get in California. That's something that's required to be produced without the need for...
Why couldn't you get that in the discovery in California?
Because we're not required to, first of all. We're a shareholder of 52%. We have a right. It's a mandatory document.
I understand, but why couldn't you get that in the as a request for discovery?
Because in California, Fair Friend is owed $300,000. It's a collection action for Fair Friend in California. But it happens to own this company in Maine, and therefore it has a right to understand what the company is doing.
Are you saying it would have been deemed irrelevant in the California action, and so you wouldn't have been entitled to that discovery?
I'm not sure if it's irrelevant or not, but the fact that that CNC's Fair Friend affiliated CEO is demoted here in Maine unilaterally without any approval of shareholders or directors, I'm not sure what that has to do with respect to a collection action where they didn't pay.
So are you saying simply it was more expedient to go the shareholder route as opposed to slogging through the discovery route in California?
I don't know that California is the proper avenue to try to find out information about corporate governance of a Maine entity in Maine.
Well, speaking of California, though, there is I think I've read somewhere in the record that CNC's principal office is in California.
That's incorrect, Your Honor. That's incorrect. And
Well,
I've briefed
Put
it.
that aside for a moment. Was there not an invitation back in August of 2019 to go and review those records in California?
There was a legal request for books and records in 2019, and the response at that time was, hey, come to California. And of course, our response is, well, this is a Maine company with a Maine domicile required to maintain records in the state of Maine.
But you did have an opportunity.
Well, at that time, I know it's difficult to grasp this from the volume of the record, but there was an agreement in April of 2021 that sought to conclusively resolve these issues with respect to non-payment of machines for all the three companies.
Has Fairfriend received all of the relief it requested in its complaint? In other words, I guess specifically, does the production of the finalized 2022 financial statement of CNC Systems complete what Fairfriend requested in terms of relief, along with the attorney's fee award?
Yes, Your Honor. Yes,
So there's
Your Honor.
nothing else for the court to do at this point?
It's a little bit of a metaphysical question because there are some open items. There were
But counsel,
subpoenas.
I'm not sure it is so metaphysical. I'm looking at 1604, and the request under 1604 is to obtain an order. It says the Superior Court may summarily order inspection and copying. It doesn't say anything about the enforcement issue. So isn't the order from March of 23 really the final order? In other words, that's all the relief that 1604 references. And so any of the proceedings beyond that had to do with essentially enforcement of a judgment, didn't it?
That's one way to look at it. But of course, we had. I'm just trying to flag that there is a second motion to stay that remained
I
open. It's
understand.
not acted on. Maybe implicitly it was denied by the denial of the motion.
I was going to say, there's still a question if March 23 wasn't open. I mean, we have typically, attorney's fees available under 16043 are often viewed as an ancillary, and they don't prevent the judgment from becoming final, right? An outstanding award of attorney's fees.
I believe that's right, Your Honor.
Okay, well, and if that's true, though, if that's the final judgment on the attorney's fee award, which was giving you a fees up through February of 2024, under subsection 3, the court it says, court shall order the corporation to pay shareholders' expenses incurred to obtain the order. And the only order that's authorized under that is an order to produce.
Well, I think, Your Honor, that as reflected in the docket, you have a number of related motions. You got the
You
motion to
do.
dismiss,
I'm
motion
not
to
sure
stay.
they're authorized under 1604 is my point. Essentially, those are post-judgment. Aren't those essentially post-judgment requests to enforce an order rather than to obtain the order, which are the only attorney's fees that are authorized?
Well, this is an issue with respect to the finality of the orders because you have 3 enforcement orders, compelling production. So you could look at them as a string of orders that are compelling production. I know also that for instance, I do want to note that the reference to bench trial, there was not going to be a bench trial. That was clear in our conferences with the court, that was just sort of a generated notice from the clerk's office.
It may also be an issue with respect to the amount of the attorney's fees ordered. I mean, to the extent that the court's award of attorney's fees reflects additional work beyond that March order, would those be appropriate awards of fees?
I believe so, Your Honor, because this is a unified action where you have a litigant who is resisting production. In order to get production, it's necessary to address the serial motions, which the court in the attorney fee order actually noted that the serial motion is intended to delay
So
the
in
production
this
of documents.
context, the request for fees may not be ancillary. It may be an element of the statutory claim itself.
Well, I do know that the court in its conferences held open the attorney fee issue until we were done production, and essentially it was
And as a
monitoring
matter of
production.
technicality, there was no judgment entered in the docket sheet, correct?
No, we have 3 orders that are compelling production at different times in the attorney fee order.
Has CNC produced all of the documents that it has been ordered to produce?
Yes, Your Honor. We
Okay, so
received that last 2022 financial statement after the filing.
The
of this appeal.
2022 finalized financial statement was the last document.
Yes, Your Honor.
So what is it you want the court to do today? Do you want us to just affirm what's happened below? You requested fees for the appeal. Is that correct?
Well, if, I think the way I phrased it, I want to be careful about the way I phrased it, but if you remand, if it's not a final judgment, then I would like the ability to update the fee request. If this is a premature appeal, it's an interlocutory appeal.
But you're not arguing that the appeal itself is frivolous, so we should grant fees for the appeal?
I have my personal view, but you know, there's plenty of gray in the law, and so it's their right to appeal. I don't believe that their arguments have merit, but
You basically want us to affirm.
absolutely, absolutely. It's not my appeal. I'm defending.
Aren't there still motions that have been docketed that are still open? They may be moot, but the court hasn't acted upon them yet. Isn't that correct?
There's one motion, it's the second motion to stay, and one way you could look at it is it was implicitly denied because the motion to dismiss was denied, where the court said, listen, the California action is not a basis to get rid of this action. So,
Or were the motions to quash the subpoenas that were
yes, Your
served?
Honor, that's correct. There are motions to quash that was held open, so there are subpoenas. But I would also say that I'm prepared to withdraw those subpoenas at this point because we obtained the financial statements from the, essentially they came from the accountant in Westbrook.
If we determine that this is not a final judgment, is it your preference that we address it in any event in the interest of judicial economy?
I think you have both sides agreeing that it's your call, but judicial economy could apply here because, of course, litigation's costly, expensive, and time-consuming. And at this point, we do have finally the production of the documents that were requested under the.
But isn't that information that's technically outside the record? I mean, that happened after this appeal was filed? Do we have to get something from the trial court certifying that it's final or something, or that there's nothing else to be done?
I don't know, Your Honor. That would be a judgment call for the law court.
Well, this is a mootness issue, and you're representing that the issues are moot. Is that correct?
I think both sides agree that
the attorney's fees isn't moot,
the 2022 financial statements were produced in September of 2024.
So that aspect of the litigation is moot, leaving only the attorney's fees question, in which case, however we would rule on the attorney's fees would be dispositive of what's remaining in the case.
Yes, I believe so, Your Honor. And withdrawing the subpoena request because of essentially what amounts to a judicial admission on each side that the 2022 financial statements have been produced finally.
And that's a foregone conclusion. If we remanded, your first thing you would do the next day is to withdraw the subpoenas.
Yes. Let me put it this way. On rebuttal, you could ask him if the motion to quash is moot, you know. And but I think that both sides agree that judicial economy. This is the type of case of this magnitude. I think that the issues involved are very important. There's a book by Judge Coffin called On Appeal, and it said that the job of an appellate court is to keep the trial court honest. I think that these statutes are designed to keep corporate governance honest. That a shareholder is able to request books and records and information, understand what's going on at the company. So it's a very important rule to stick up for the rights of shareholders in Maine with respect to information rights. So even though there's not a huge amount involved here with respect to the attorney fee question, it's an important issue with respect to shareholders' rights and ensuring that Maine corporations are governed properly.
Thank you.
Thank you, Your Honor.
Attorney Malagonis? You agree that all documents have now been produced?
I do, yes, Your Honor.
And so the pending motions regarding subpoenas, et cetera, are really essentially moot at this point?
I believe so. And I think for the financial statement, we had produced all of the underlying financial, the balance sheet, the general ledger. all of that stuff previously. It was just the finalized form from the accountant that was produced later on. I wanted to add, too, I believe it was Justice Douglas's question about the documents produced in California. We included in the November 2022 motion to stay the discovery requests that were propounded by Fairfriend on CNC. And as part of that, there were requests for shareholder records, requests for tax returns, meeting minutes, and those documents were produced separately in the California action and then reproduced as part of our production following the court's order. So those documents were produced and requested in both actions, and the discovery requests in California were served before CNC even answered the main complaint. Again, which is our position that it just goes back to these were all documents that could have been obtained as part of that proceeding, but were not, and then were sought through the main statutory request. No further. All right. Thank you.
Thank you, counsel. As is our usual process, we will take the matter under advisement and issue a written decision in due course. And we'll be in recess on this matter. is Waldo 24-236, Alicia Rowe versus State Mutual Insurance Company. We are being streamed, both by video and audio. I would ask counsel to identify yourselves by saying your names for the record, starting with the appellant.
Jeffrey Edwards, Pretty Flaherty, for appellant Alicia Rowe.
Good morning. Matthew Mahalik for Appellee State Mutual Insurance Company.
Thank you. And Attorney Edwards, if you're ready to proceed, we'd be happy to hear your argument here this morning.
Thank you, Your Honor. May it please the court. This is an appeal in a regional apply action brought by Alicia Rowe against State Mutual, seeking to enforce and collect a judgment that she recovered against State Mutual's insureds, William Chase and Gwen Chase. Contrary to the trial court's decision below.
Mr. Edwards, I see that the green light is on.
Absolutely.
If we accept your interpretation of this exclusion, doesn't that mean, doesn't that lead essentially to I can have a homeowner's policy and acquire all the commercial or tenancies I wish during that year, and they'll all be covered automatically under my homeowner's policy because I'm going to rent them to somebody else to use as a residence?
Well, I mean,
that seems pretty outside the contemplation of what that policy is supposed to be covering.
well, I mean, in terms of the definition of an insured location, clearly the policy does provide for automatic coverage for property, structures, and grounds acquired during the policy term.
With a limitation.
With a limitation, though, that it's to be used as a residence.
Correct.
isn't the
So your position then seems to me that if let's say I'm regularly in the business of being a landlord and have many properties, that any time I acquire a property during the period, I don't have to bother getting my own separate policy for that residential property. It's covered under my own homeowners.
Well, it would be temporarily covered till the renewal period. Obviously, it's automatic coverage because you're acquiring this property midterm in the policy, but it would only extend to situations in which you acquire the property during the policy period for use as a residence.
But isn't
Let me
the
just
policy
interrupt you there.
limited further?
You said a residence. Policy language says period for your use as a residence.
Yeah, as a residence as opposed to your residence. An insured can acquire property for use as a residence. They can live there.
For your use as a resident, stop omitting that word.
Pardon?
For your use as a resident.
Your use, yeah, but an insured, you're referring to the insured. An insured can use a residence by living there, by renting it to a third party to live there, or by letting their relatives and children live there for free.
Counsel, you represent insurance companies, I'm sure, or have in the past.
I sure have.
Aren't there completely different underwriting concerns or principles that apply with respect to one's residence and one's rental properties?
Well, I mean, if the insurance company wants to protect itself, it needs to draft the policy in a tighter fashion. It's not for the court to fill in the blanks or to add language to basically affect the intent or to protect the underwriters for State Mutual Insurance Company. The policy states that if you acquire property for use as a residence, and again, there are a number of ways that a property can be used by an insured as a residence, then it's covered automatically under that particular definition of an insured location.
Justice Lawrence, were you trying to jump in?
I think we covered the point. Okay. Thank you all.
I mean, again, it's a matter of draftsmanship, I suppose, and I think that the policy clearly in this fact pattern, and it's undisputed, the mobile home where this accident occurred was acquired during the policy period, and the Chases intended to rent the property to use it as a residential property for tenants.
Well, how about the exclusion?
How should it have read? It says for used by you as your residence?
Well, that's the way they should have done it. I mean, if they wanted to have a tighter language. Obviously, for example, in other parts of the policy, in their definition of residence premises, they include the property where you live. In other words, if they want to impose that restriction on the definition, that it only includes property where you live, where you occupy, where you're in place, then they could have drafted it that way. But they left it in a general fashion. A residence is a general reference to a use, and again, an insured can use a property like the one in here, the mobile home, as a residence by living there, by renting it, or by letting relatives or children or friends live there for free. I mean, it's still
how
being used as a
about
residence.
the exclusionary language? So looking at Section 2, exclusions, E, coverage E. Coverage E and F do not apply to the following: for insured's premises not an insured location, bodily injury arriving out of a premises, and under the exclusionary language, they put in rented to others by an insured. That is not an insured location. It's a little bit, the language kind of doubles back on itself there. But aren't these, doesn't that suggest that if it's rented to another person, even if it's owned by the insured, that it would not fall under the scope of the bodily injury coverage?
Well, they're just defining different types of properties that might be within the ownership of the insured. Obviously, that language, in terms of making that consistent with other parts of the policy creates a problem, I suppose, in the sense that obviously by putting it in there, it contemplates that you'll own the property, you'll occupy the property, or you might rent it to a third party. But I'm just saying, for the limited purpose of this exclusion for bodily injury arising from a premises that's not an insured location. I mean, insured location is a defined term. On the plain meaning of that language in the definition of an insured location, it doesn't impose the requirement that the insured actually occupy and live there. If they had intended to do that, they would have drafted it like they had done in defining a residence premises, where they describe the property as being where you live, or where you reside, I should say.
Can I ask another different question? So when we talk about, well, let me back up a little bit. So that exclusion, it depends on the property having been acquired during the policy period, correct?
Correct. It's automatic coverage. You have the same in many policies.
So here, what we have is real estate that was not acquired during the policy period and a mobile home that was reacquired during the policy period, correct?
Correct.
So how do we know that meets the definition of acquired during the policy period?
Well, it says right there in the definition of insured location, it extends to premises, structures, and other grounds acquired during the policy period. I would contend that the mobile home certainly would be a structure acquired by the insured during the policy term. Again, I think it's clear that the accident scene, the mobile home owned by the Chases, was acquired during the policy term.
So is it because it says the part of other premises, structures, and grounds used by you as a residence?
Right.
Which was acquired? So that's what's indicating to you that the acquisition of the mobile home is the determinative piece as opposed to the acquisition of the real estate?
Well, the acquisition of the mobile home during the policy term, plus the intent to use it as a residence by renting it to third parties, potentially like my client Alicia Rowe, which is why she was there the day she got hurt. So I think I would submit that this exclusion for bodily injury arising out of a premises does not apply simply because that mobile home on the day of this accident was an insured premises because it was acquired during the policy term for use as a residence.
For your use as a residence.
For your use as a residence, yeah. But again, your use, an insured can use a property by living there, by renting it, or by letting their children and relatives live there for free.
But as the Chief pointed out in the opening comment, that's a very expansive use of the word your, use it in any fashion.
But it does, the adjective your doesn't come prior to residence, for your use as a residence, not your use as your residence. The language could be tighter, but that's State Mutual's job in drafting up their policies to tighten up the language, to eliminate ambiguity, and to make it achieve the outcome that they want. It's not for the court to fill in the blanks and throw them a lifeline and say, this is what they really meant, and that's why we're going to rule in a particular way.
Are you arguing that it's ambiguous, or that the clear interpretation would be your use means basically you acquire something during the policy period, and as long as it's residential, it's covered.
That's correct. That's the way it's drafted. The plain meaning is if you acquire this property, this mobile home during the policy term for use as a residence, it's covered by the plain meaning of the language.
If we
But-
look outside Maine to
Pardon?
see, if we look to see what other states' courts have done.
There are no other cases interpreting the language
There's a
of this.
Florida appellate case, there's 544 F3rd 553 at 560 that seem to be contrary to your position.
I don't think so, Your
Do you
Honor.
have any cases that are supportive as to this language for your position?
To my knowledge, there are no cases reported that interpret the language in this policy that's at issue in this appeal. The cases cited by the appellee, the cases cited by the trial court, all involve cases interpreting the policy term residence premises, and that's not at issue in this case.
Under your interpretation, if the Chases had acquired a 50-unit apartment building, all of the apartments being residences, all of those units would be covered under their homeowner's policy.
For at least till the end of the policy
Well,
period.
till the renewal date, but, I mean, again, that's the way the policy's drafted, Your Honor.
So your answer is
And
yes,
I
they
mean,
would all be covered.
The Chases didn't draft the policy. Alicia Rowe didn't draft the policy. You know, if insurance companies want to achieve outcomes in the drafting of their coverage in their policies, then they should draft it appropriately. But I think they've, at the very least, they've created an incredible ambiguity in terms of whether this is would apply to a situation where you acquire a property during the policy term for rental, and as opposed to, again, it doesn't explicitly in the definition of insured location require that the acquired property be occupied by the insured. It only requires that it be used as a residence. And again, the insured can use it as a, not to repeat myself, but again, they can use it as a residence by living there, by renting it, or by letting someone live there for free. I mean,
I will ask you to repeat yourself. The answer to Justice Horton's question was yes?
yes.
Okay.
And the way the insurance companies protect themselves from that scenario is to draft their policies appropriately to exclude that situation and make it clear that they want the insured to actually be occupying, living there, and changing their clothes in the property in order for it to be an insured location. And they didn't do that in this case.
And to follow up to Justice Connor's question, you're not aware of any authority that supports
There is-
your interpretation of this language in that fashion?
There is not, to my aware, that I'm aware of, and again, I would state that the cases cited by the appellee and by the trial court below do not interpret the language at issue on this appeal.
It's not part of our analysis here, but I'm just thinking out loud. What underwriter would ever enter into an agreement whereby an insured can acquire all sorts of commercial properties, unlimited, and get coverage for this unlimited exposure? It's not part of what we need to address here, but I'm just
No, but I
thinking
mean,
out loud.
I don't know that the underwriters do it or who's drafting up the policies, but at the same time, you know, if you want to achieve an outcome, I mean, it's a draftsmanship issue. I mean, the policy as drafted, the plain meaning of the language, in my opinion, requires that there be coverage because this particular mobile home was an insured location at the time of the accident because it was acquired during the policy term and was to be used by the insured as a residence in the sense that the insured intended all along to have the property rented.
Doesn't the case really come down to the meaning of the word use? In other words, can somebody be said to be using a structure as a residence unless they occupy it as a residence? Doesn't use mean occupy?
I think if
pretty
you
clearly?
rent a property to somebody as a landlord, you're using the property.
But it wasn't occupied by the tenant either. I mean, to Justice Horton's point, it says grounds used by you as a residence. It wasn't, in fact, being used as a residence, was it? It was
Well,
empty.
it was in transition for sure in the sense that the
It wasn't, in fact,
the Chases
being
were in the
used.
process of remodeling the property in order to have it rented
It
to
wasn't being
third
used
parties.
by anybody as a residence on the date of the incident, was it?
I mean, but it was acquired for the insured's use as a residence. I mean, I don't know that
That's
there's...
not what the policy language doesn't say acquired
let's say
for.
acquired by you for, it doesn't say when you're using it as a residence. I mean, it just states that you have to use it as a residence.
But it wasn't being used as a residence on the date of the event that's resulted in this suit.
Well, it was certainly being transitioned into that.
But it wasn't actually being used at that point in time, was it? As a residence on that date.
Nobody was sleeping there, Your Honor, but
No one was
certainly
residing there either, were they, counsel?
the Chases were remodeling the property.
But no one was residing there, were they, counsel?
No, but in terms of...
Okay. Thank you, counsel. The red light is on. Thank you.
Thank you.
Attorney Mihalik.
May it please the Court, Chief Justice Stanfill, and members of the Court, my name is Matthew Mihalik, and I'm here today on behalf of Appellee State Mutual Insurance Company. This case concerns the enforcement and application of unambiguous exclusionary language of a mobile homeowner's policy. Regardless of how appellant characterizes her claims, the fact remains that a defective condition of the property at 23 Winnicook Road in Burnham, Maine, caused her injury. That property was not an insured location on the policy, and it wasn't an insured location on the policy for two separate reasons. In looking at the definition of an insured location, it requires that in order for it to be an insured location, the part of other premises, other structures and grounds used by you as a residence and which is acquired by you during the policy period for your use as a residence. This mobile home and the property upon which the mobile home sat had been owned by the Chases for approximately 25 years at the time of Miss Rowe's injury. In addition, the location was never used by the Chases themselves as a residence. In order to give the language of the insured location definition the meaning that's argued for by appellant, it would be necessary to read out of the policy language that is included in the policy. And appellant's counsel specifically stated in his argument that it's not for the court to fill in the blanks or add language to a policy. It's to apply the language that's in the policy, give it the meaning of what has been drafted, and apply it to the facts of the present case. In this case, it requires that the use of this residence be by the Chases themselves, by specifically stating for your use. Your is the two
Attorney
named
Mihalik, I
insurers.
see that the green light is on, and I want to go back to something that I thought I heard you say and make sure I understand you correctly. You said that both the real estate and the mobile home on it had been owned by the Chases for 25 years.
I apologize, Your Honor. Just the real estate was owned by the Chases
Okay.
for 25 years. It's agreed that the mobile home was acquired in September of 2019, reacquired by them.
And so doesn't that meet that part? I understand there was another issue, but doesn't that meet that part of the requirement that it be property acquired by you during the policy period?
I don't believe so, Your Honor. In looking at the...
Well, it doesn't talk about the whole real estate. It talks about the part of premises or structures used by you and acquired by you.
But there's not a comma after other structures. It's other
There
structures
isn't?
and grounds.
But one certainly cannot use bare real estate as residence, or, well, there are people who do, but ordinarily one would not think of that as being a resident, being used as a residence. It requires the acquisition of a mobile home, does it not?
I would concede that point to
So,
Your
I mean,
Honor.
it seems like your better argument is really
Well, regardless of the fact of whether or not the reacquisition of the mobile home is an issue in this case, it still leaves us with the issue of whether or not the Chases needed to use this mobile home as their residence.
Understood.
And
What's your response to the argument that the case law that you have cited from other jurisdictions is not relevant because it relates to the definition of residential premises and not insured location?
Well, I disagree. I read both of the cases yesterday, and there are specific provisions in both, well, in the Harrington versus Citizens Property Insurance Corporation, the exact same provision and definition of insured location that we're dealing with in the present matter is dealt with in that case. It's not in great detail, but it is dealt with, and the court specifically states the other premises must be used by the insureds as their residence based on that language. In the Gardner v. State Farm Fire and Casualty Company decision, it's not identical language, but the language of the part of the policy that was construed by that court was any part of any other premises used by you as a residence. Similar language. In both cases, those courts required that the insured be the one that's using the property as their residence. They actually be physically residing at that property. So I believe that those two decisions do support the argument that's being advanced by State Mutual and myself, that it is necessary that the residence be used by the Chases themselves as their residence.
As we're really, the tipping point here is 6 words in the policy: for your use as a residence. Mr. Edwards says, yeah, they're using it as a commercial residential property. That's how they're using it. And you say, no, it means you have to live there yourself. So if reasonable minds can disagree on what those 6 words mean, doesn't that suggest that there is a latent ambiguity in the language?
Well, with all due respect to my fellow counsel here, I don't believe that his argument is a reasonable interpretation of the language.
But if we were to determine that it was ambiguous, we would be construing it against the insurer, correct?
If the court found that the language was ambiguous, the precedent from this very court holds that you must construe it against the drafter.
What about the tense in the first part of subpart B? In other words, that the part of the premises, structures, grounds used by you as a residence, and the fact that nobody was actually using it as a residence at the moment.
That's a very valid.
It wasn't occupied.
It's a very valid point. It was not being used at the time of the injury.
Have you looked at that issue at all?
That was not briefed, but you know, it's a valid point to raise that. But I would also say that when we look at this definition in its entirety, there's so many requirements of you, the named insureds, using it as a residence, that it makes it clear that the use must be by the named insureds as opposed to someone else, such as a tenant. It says in the first part, the part of other premises used by you as a residence, which is acquired by you during the policy period for your use as a residence. Appellant wants to add another "your" into that definition, which is, in my opinion, would be superfluous to identifying what the real intent is and what the real meaning is behind this definition.
But if it did have that second word, that would ice the whole thing. Nobody could remotely argue. If it said for your use as your residence, that would nail the thing down with absolutely no possibility of a latent ambiguity.
Well, I don't think there is an ambiguity as it's drafted. You know, it would be adding a fourth instance of you into a definition where you and your are already included 3 times.
And you don't want us considering remedial measures that may or may not have already been taken anyway.
The appellant's argument really is that the term used by you, or your use, means something more than occupation, and that's maybe somewhat supported by the part of the definition of insured location that refers to, and this is part D, any part of a premises not owned by an insured where an insured is temporarily residing. So why doesn't the rest of the definition of insured location refer to where an insured is residing instead of used by an insured? It just seems to me that that might lend some support to the claim that the term used is broader than residing at.
I don't believe that's the case, because I think that subsection 2, where it specifically states for your use as a residence, for the insured's use as a residence, you know, in the earlier part, in the introductory language to subsection B, where it states used by you as a residence, we're
And
adding
again,
some other
subsection F
qualifier
says,
to it is
subsection F
redundant.
refers to land on which a dwelling is being built as a residence for an insured. That clearly, at least in my view, means that the insured is residing in that dwelling, as opposed to using the dwelling, which Ms. Rowe is saying means something broader than residing there.
The qualifier of for your use as a residence, I think, in my opinion and State Mutual's opinion, signifies the requirement that the property itself must be used by the insureds as their residence. In order for the language to have the interpretation that appellant argues for, the language would have to be the part of other premises, other structures and grounds used as a residence, and which is acquired by you during the policy period for use as a residence. It would totally read out of the definition used by you as a residence and for your use as a residence. And that's exactly the thing that the court is not supposed to do, which is rewrite the policy as it's written. It's to give application and interpretation to the language as used and drafted by the insurer and agreed to by both of the parties at the time that they entered the contract. Addressing the other issue that's been raised by appellant about the bodily injury not arising out of the uninsured location, assuming the court agrees that this was in fact an uninsured location, which is the position of State Mutual. I think the precedent from other courts that have dealt with this specific issue make it clear that by trying to characterize the claim as a failure to warn as opposed to a defective condition in the property itself is not a valid argument. In the Green Mountain Insurance Company versus Wakeland decision, which the parties have spent a great deal of time discussing in their briefs, the court specifically looked at or stated that with respect to a portable generator at a camp that caused carbon monoxide poisoning to the individuals that were residing or were staying overnight in the camp, that the portable generator was exactly that, portable. It wasn't a fixture of the property. It wasn't a condition of the property. It was a movable item. Therefore,
Weren't the steps moved here?
but they weren't something that would be taken off of the property. We're talking about a front entry deck with steps that were
I'm just noting
merely,
they were actually moved. That's what the whole problem is.
well, it was still a condition of the structure. You know, a door that's attached to a structure can be moved, but if it slams and hits somebody in the face at a location that's not an insured location, the injury would still arise out of the door itself. Here, this is a condition. The allegation is also that there was insufficient lighting at the property. That's a condition of the property. In fact, the Wakeland court specifically gave a number of examples where they said the generator here did not resemble any property condition that typically gives rise to personal liability, such as the loose board, the falling roof slate, the defect in the walkway, or the failure of outdoor lighting. Clear, and that is taken from another decision from Massachusetts, and if you look at the history of all of these cases, they go back a number of years, and that is the general interpretation that is applied to this this provision of the policy that's looking for conditions of the property that cause an injury and whether there's a causal connection between the injury and the defective condition. And that is what's at issue here in the present case.
Well, does the fact that there was a failure to warn about the condition of the premises, in other words, the negligence in not advising Ms. Rowe of the condition of the premises when she arrived, does that take it out of this exclusion?
No, because the exclusion language uses the phrase arising out of. And this court, in past decisions, Acadia Insurance Company versus Vermont Mutual Insurance Company, said that that language means that the injury in some proximate way has its origin, its source, or its cause in the uninsured location, or the injury originated from, grew out of, flowed from, was incident to, or had connection with the uninsured location. So regardless of the fact that there may be a failure to warn issue, you still meet this standard which has been announced by this court in interpreting the arising out of language. Additionally, other courts, the Superior Court in specific, Justice O'Neill, looked at the motor vehicle exclusion in the Merrimack Mutual Fire Insurance Company versus Capilupo case, where there was a snowmobile fatality, and the claim to try to get around the motor vehicle exclusion was that the cause of action was negligent supervision. And Justice O'Neill, relying on other decisions, I think one of which was from this court, said that that doesn't get it around the exclusion, where the exclusion uses the language arose out of or arising out of, because the fact remains that the injury arose out of the use of a motor vehicle, no matter what you qualify the cause of action as.
Thank you,
Thank you for
counsel.
your time.
Attorney Edwards, you reserve.
Thank you, Your Honor. I only have a minute, so I'm going to have to talk quickly here. But with respect to a second point, this insured location exclusion does not apply because the bodily injury suffered by Alicia Rowe on October 30th, 2019 arose out of the independent tortious conduct of the Chases, in the sense that they were engaged, the Chases...
Isn't it always tortious conduct by an individual? I mean, you don't sue the property for an for an injury. You always sue the individual.
Right,
You're always alleging
you sue the
tortious
individual,
conduct.
but the point I'm trying to make is that this is not a case, the underlying case against the Chases was not based upon premises liability or their liability as a
There wouldn't
landowner.
be a failure to warn action if there weren't a defect in the premises, though, would there?
But the obligation to warn arose out of their independent tortious conduct in doing this remodeling project, creating a gap, and then failing to warn Alicia Rowe about the gap. It's not unlike a situation where the insured is chopping down a tree and fails to yell timber so that it doesn't hit somebody. It's the conduct of the insured.
Thank you.
Thank you.
Thank you, counsel. As is our usual practice, we'll be taking the matter under advisement, issue a written decision in due course. And we'll be in recess on this matter.
All rise.
And you may be seated. My apologies for the delay. We are on the record. Let me get my chair up here. In Penobscot 24-253, State of Maine versus Jeff, is it Bellany?
Yes, Your Honor.
Okay. And we are being streamed live on the web, both by audio and by video. I would ask counsel to identify yourselves by saying your names for the record, together with the parties you represent.
Yeah, thank you. Hunter Tavares for Helen, Jeff Bellany.
Katie Sidley for the state. Okay. Counsel, before we proceed any further, I have to bring to your attention an issue that is a significant one. As you know, in this case, there was an order issued in June pointing out that the notice of appeal was not timely filed from the judgment and commitment in this case. However, because the judgment was thereafter amended, the order said that the appeal would proceed at this point. The court as a whole, however, needs to make that decision. If an appeal is untimely, we have no jurisdiction. We can't change those deadlines, is our understanding. Rule 38, of course, stays the judgment automatically pending appeal if the defendant is admitted to bail, which I believe he was in this case. The order amending the judgment was entered one day after the notice of appeal was filed, pointing out to you that ordinarily once a notice of appeal is filed, the trial court may be, in most instances, divested of jurisdiction to do anything further. So we've got a bit of a quandary here. However, because of the order that was entered in June, obviously neither party addressed these issues in your briefs. And so what we want to know is, well, what we plan to do is to give you an opportunity to file supplemental briefs, if you would like to, on the timeliness of the appeal, and most importantly, what that really means is this court's jurisdiction to reach the merits of the appeal. Rather than have an argument here today on the merits, what we would propose is once those briefs are submitted, we will then reschedule oral argument if we believe we have jurisdiction to reach the merits.
I understand what you're saying, Your Honor. Just for the record, I don't agree the appeal was filed late.
I understand.
I didn't prepare this for today, but I understand my recollection is we brought it to the courthouse. It was filed on the date it was supposed to be filed, but it may have been docketed late. So
Okay.
I'll address that on there.
Well, and that may be something you need to address. So what I would propose then is to give you to January 24th to file any supplemental filings. I think that's 2 weeks from Friday. Did I do my math correctly? Is that a problem? You made a face, Attorney Sibley.
My math isn't great either, Your Honor.
Oh, okay. Is that sufficient time, do you think?
I will make a sufficient time, Your Honor.
Attorney Tavares?
Yes, and is that going to be filed with as a motion or by just briefs like we typically file?
Briefs.
Okay.
And simultaneously. Because it's a jurisdictional issue, it's not really a supplemental issue so much as it's a jurisdictional issue. So the question is, can we reach any of the merits of the appeal? And so rather than hear arguments on the merits today, we will reschedule oral argument if we think we have the jurisdiction to reach the merits. I'm sorry I know that was a big pin in a big balloon. But I know that the language of the order from June, I know that neither of you briefed the timeliness issue, and that the language of the order from June really meant it could proceed, we can't waive jurisdiction, and that we would hear what you have to say, but since this issue wasn't briefed, we want to give the opportunity to address it.
Thank you.
Okay? So I'm afraid, like I say, a big pin in the balloon, but I think that's it for today.